Okay, good afternoon, everyone. Thanks for being with us. Just a little late to set everything ready to start. So today, for our AI Society seminar series, we have a special guest from the United States. James Heilpern is with us. James is an accomplished lawyer and legal scholar affiliated with BYU Brigham Young University in Utah. It's a great school, great law school. He's also a great friend of mine. And he's one of the pioneers of a new discipline that blends law and data in a very fruitful way. The bread and butter of lawyers has always been try to guess what law means. And James has been one of the first intellectuals to try to use data and big data more precisely to help lawyers and judges alike to make legal arguments based on what law means. We all know how important it is that we figure out what the law means since we are subject to the law. And this does not apply just in the United States, it applies everywhere. So today we will peruse his career and how he came to delve deeply into this new discipline, and he will share his wisdom with us. After his presentation, we will have a chance to interact with him. For those who are following us through YouTube, they can send an email asking questions to aisociety.unipd@gmail.com. Those who are following us, who are attending the seminar through Zoom, they can use the Q&A section and start chatting. So James, thanks again for being with us. The floor is yours.
All right, thank you, Dr. Penn. First off, I just want to say how grateful I am for the invitation to present to all of you. And also, I regret greatly that I'm not able to be there in Italy with you, both because I would love to visit Italy, but also I met Dr. Penn the first time when he came to my university when I was a law student, and while he was there, we developed a close friendship and have stayed in touch over the years. And so I greatly regret the fact that we won't have that proximity to be able to form those sorts of relationships. But I will share my email at the end, and especially for the students watching, I certainly am eager to pay forward the friendship that Dr. Penn has shown me and the mentorship that he has shown me. And I am happy to assist in your careers in any way that I can, even if it's just answering questions or putting you in touch with people, as Dr. Penn has done for me. Now, Dr. Penn asked me to begin by sort of sharing a little bit about my career and how I wound up at this crossroads of the law and big data. So I'll just spend a couple of minutes providing you with some background on me. I attended law school at Brigham Young University, and basically the short answer to Dr. Penn's questions is serendipity. I fell into this space through a series of coincidences that have happened throughout my career. So I attended law school at Brigham Young University, which just so happened to be the first law school have some scholars starting to think about how to use big data to better interpret the law. That movement really began back in 2011 when a law student by the name of Stephen Morrison was a new law student at BYU. He had a master's degree in linguistics, and he was reading these Supreme Court cases that were basically attempting to figure out what the law meant and analyzing the meaning of the law. And as a first-year law student, he was saying, well, that's not how language works. That's totally wrong. And he wrote what has come to be known as the greatest, the most influential student law review article of all time, where he basically said what the Supreme Court is doing doesn't make sense, and here's a better tool. Now, a lot of that article is now dated as the methods and the technology has emerged, but it kind of caused a firestorm, at least within those academics who started thinking about interpretation and how to get at the meaning of language. Now, Stephen Morrison went on to have a successful career as a big law lawyer. And my third year of law school, he was invited back to teach as an adjunct, to teach the first course in the United States on law and corpus linguistics, on using big data to better interpret the law. And it was a very experimental course. In fact, there were more professors of that course than there were students. And I just happened to be one of the handful of students who was, had the foresight or maybe was stupid enough, I'm not sure, to sign up for this experimental course on this subject that literally no one had ever heard of. Well, fast forward to my own graduation. I graduate, and as a lot of aspiring academics who come out of law school, I went and I worked for the United States Judiciary for a few years. I worked for a trial court judge in Detroit for a year, and then I worked for an intermediate appellate judge for a year in New Orleans. And I had accepted a job at one of the largest law firms in the United States, a firm called Gibson Dunn, working with their Supreme Court practice group. And we were, my wife and I were full steam ahead and planning on moving to the nation's capital. And the plan was to, quite frankly, was to be miserable for 2 years, because working at these big law firms, no one is particularly happy working at big law firms. They kind of work you to death, and they pay you a lot of money that you don't have time to enjoy. And that was the plan. And then I got a phone call from the dean of my alma mater, Professor Gordon Smith, who was one of the first professors to start thinking about these issues. And he essentially said, hey, we just got a pot of gold. We got a grant. And, how would you like to work for slave labor, for slave wages? You could come back to BYU, you could be a visiting professor, and you could help us run the Law and Corpus Linguistics project. And my wife and I, in full disclosure, we're very religious people. We prayed about it, and honestly, the biggest reason that pushed me is I had a new son. I had a brand new son who was 3 or 4 months old, and I had a colleague at the court who had come from big law, and he said, recognize that if you go to that big law firm, you won't see your son awake for 2 years. And so I looking at my son Jack and praying about it, we decided to go back to Utah. And since academia was always the long goal, we just decided to start that academic career a little early. And so I wound up at BYU and was tasked with trying to figure out how to expand the field of corpus linguistics, how to build more databases that would be useful to lawyers. And also, one of the tasks that I took upon myself was how do you evangelize? How do you get the word out about these new tools? And I am happy to say that after 2 years at BYU, we went from nobody knowing what corpus linguistics was in the legal field to pretty much everyone knowing what corpus linguistics was and everyone thinking it's a bad idea. And that is progress. As Mahatma Gandhi once said, first they ignore you, then they mock you, then they fight you, then you win. And right now we are in the turning point between. Well, right now we have there's sort of two paths that are going on right now. The first is what's going on with judges on the country. I have spent the last about 3 years going around the country and training judges on state Supreme Courts and on federal circuit courts. That's the intermediate appellate courts. And I can tell you that by and large, most judges are very interested in this. It's very rare that a week goes by that I'm not in correspondence with some judge. It's not unusual for me to get an email from a judge saying, "Hey, can you train my clerks and teach them how to use these tools?" And just over the last 2 years, we've seen really an explosion of judicial opinions where judges have used these big data tools sua sponte. And we're seeing increasingly judges, especially in particular jurisdictions such as Utah and Idaho and Michigan and the Sixth Circuit, increasingly put pressure on lawyers to start using these tools. Now, at the same time, and now I will just say, since the judiciary seems to be increasingly on board, I would say that it is inevitable that this will become commonplace. Nevertheless, I present that as a backdrop for this second phenomenon that is happening, which is a whole bunch of academics who I greatly respect, writing law review articles, taking pot shots at this new discipline, and arguing that it's a bad idea and we shouldn't do it. So there's a lot of, if you were to go on to, if you have access to, something like SSRN or Westlaw or Lexis to be able to search through American legal scholarship, you would see a lot of very smart, very intelligent law professors who I greatly respect, who basically discover one flaw, will discover one flaw or one weakness in this new methodology that I'm going to talk about, and then they will declare victory. They will say, "See, I have proven that this is a very bad idea," and then move on. And we love these law review articles because, quite frankly, it makes our scholarship better. You always want a good critic. You want smart critics who can point out things that you haven't seen before. And over the last handful of years, as we have engaged with these critics, some critics have become converts. So there's one very talented legal scholar named Jill Anderson, who's at the University of Connecticut. I like her a lot, both as a person and as a scholar. And at the beginning of the movement, maybe 5 years ago, she was very critical of law and corpus linguistics. And now she serves on BYU's board of advisors for the Law and Corpus Linguistics project. And she frequently presents at our conferences. So that's all background. I fell into this because I cared about spending time with my family. And since I came to BYU, I continue to be a senior fellow at the law school, helping run their Law and Corpus Linguistics project. I am also, I wear a lot of hats. I serve as, another coincidence that happened is there was a case pending before the US Supreme Court that was ripe for a corpus linguistics analysis. And a friend of mine alerted me to this case, and I quickly, in the course of about a month, wrote what's called an amicus brief to the US Supreme Court, where I wasn't a party, but I wrote to the Supreme Court and said, well, here's some cool data, and I think that you should use it in your opinions. And this is what corpus linguistics has to say. And in the United States, I assume it is similar in Italy. In order to submit a document to the court, you have to be a member of that court's bar. And at the time, I was not a member of. I'm still not a member of the Supreme Court bar. My time period just. I'm now eligible to become a member, but at the time I was a new lawyer and I couldn't. And so I went to a professor who I had served as a teaching assistant for when I was a law student. He ran a Supreme Court practice clinic at BYU, in addition to running his own Supreme Court boutique, a man by the name of Gene Scher. And I said, hey, I need someone who's willing to sign this brief along with me so that I can submit it. And he read it, thought it was great. He signed it, and then he hired me. And so for the last 3 years, I have been first an associate and now counsel at a Supreme Court practice boutique named Scher Jaffe. And simultaneously, these judicial trainings that I've been doing have become the demand has been so great that I've actually established a nonprofit organization known as the Judicial Education Institute, and I'm president of that. And our goal right now is focused on corpus linguistics, but moving forward, we want to train judges in not just corpus linguistics, but other emerging tools of interpretation and emerging technologies. There's a somewhat famous legal case in the United States back in 2007, where an octogenarian, an 80-something-year-old judge was reviewing some motions about a particular subject and asked the attorneys to explain what email was. And so there is a great need to educate the bench, especially some of the more elderly judges, about some of these emerging technologies that are really shaping our society. And so that's sort of the goal of this new organization. So that's my background. But you certainly didn't sign on to this because you wanted to hear about the biography of James Heilpern. So let's talk about corpus linguistics. Let's talk about what it is and what it can do, and then maybe talk a little bit about what I see as the future of law and corpus linguistics, which I think ties in to your program quite a bit. So I'm going to share my screen here in a moment. Dr. Payne, can you give me a thumbs up if you see that? Great. Okay. So the first question I usually get when I talk about corpus linguistics is what the heck is corpus linguistics? And linguistics is, of course, the study of language, and a corpus is just a fancy Latin word that means a body of texts, or in our more modern parlance, we would say database. It's once you put this body of text on the computer, it becomes a database. So corpus linguistics is simply the use of large electronic databases of language, of a particular language, to study speech patterns or writing patterns. And the second question I usually get is, as lawyers, why do we care about linguistics? And the answer to that often surprises lawyers and judges, and it's because whether we realize it or not, lawyers and judges ask ourselves linguistic questions every day. Now, I am coming from the United States is, of course, a common law system. I believe Italy is a civil law system. And so some of these questions might be a little bit different, but at least in the common law world, everything we do is asking ourselves, as Dr. Pinn asked, is trying to guess what the law means, what the words on the page actually mean. So in the United States, it's very common for us to ask, what is the ordinary meaning of a statute, or whether a particular legal term is ambiguous, or whether a particular word or phrase that's in a particular law has acquired a specialized meaning within a particular industry or a particular group that the law is governing. If you move over to trademark law, there's a lot of questions about whether or not a particular trademark has become generic. And in the constitutional space, especially in the United States, there's a lot of questions about what was the original public meaning of a particular phrase in a state or a federal constitution. And all of these questions fundamentally boil down to, what do the words on the page mean to a particular group at a particular time? Now, this guy here, this good-looking fellow, is a guy named Professor Larry Solem. He's a very prominent professor at Georgetown University, one of the best law schools in the country. And he was an early convert to Corpus Linguistics. And at our very first Corpus Linguistics conference, which we host every year, Larry Solem said, Corpus Linguistics will revolutionize statutory interpretation. And I would add to him, I think it's going to revolutionize constitutional interpretation and contract interpretation and potentially trademark and patent law. But it certainly is shaping and changing the way that judges interpret statutes or laws that are passed by legislatures. Now, I don't have time to talk about all of these, but I've given a lot of thought to Professor Solem's comment. And as I look over the last 10 years and think about ways in which corpus linguistics is revolutionizing the practice of law, there's three things that really stand out to me. Number one, it's transforming the type of evidence that judges rely on to make their decisions. And by extension, it's transforming the type of evidence that lawyers are providing to judges to make their arguments. Number two, and I think that this is the part that is actually going to be the most influential, and unfortunately, it's getting too far into the weeds to really be able to cover in a 35 or 40-minute lecture. But it's forcing an evolution in our legal theory. I'm sure that you have seen this in other spheres with the applications of big data. But once we have started to quantify the questions that judges are asking, we have discovered that maybe we're not asking the right questions. And we have discovered that there are large holes in our legal theory that we need to fix. And maybe we can get into that into the Q&A section. And number three, which is related to 1 and 2, it's calling into question a lot of the traditional canons of construction. There are, over the centuries, judges in almost every culture of the world have developed these rules of thumb that they use in order to get at what the law means. So to cite just one example, in the United States, there's something called the rule against surplusage, which basically means that that if one reading of the law would render a particular word or phrase redundant, well, then that can't be the proper meaning of the law, and we got to find a different interpretation so that every word is doing something. And the problem is at least in English, and I assume in most languages of the world, as human beings, we are a redundant species. We speak redundantly all the time. And so, recent scholarship, including an amicus brief that I submitted to the Supreme Court a couple of years ago, just demonstrates the fact that maybe the rule against surplusage isn't a really great canon, a really great rule of thumb that we should be relying on. So I want to focus on this first question, and let's start by just asking the question: how do judges answer these linguistic questions as it stands? And this is an oversimplification, but there's kind of 3 or 4 major tools that judges use that are sometimes called the judicial toolbox. And the first one is just intuition. If you look at legal opinions in the United States, and I assume in Italy as well, you will see an awful lot of you'll see an awful lot of judicial opinions that say something like, the ordinary meaning of X is Y. Period. And they'll provide no justification. It's just sort of a "thus saith the Lord" moment, where the judge in their black robes sitting on high just opines about the meaning of language and says, well, this is obvious. And the problem with this is, I'm not saying that we should throw intuition out the window, but if there's anything that the big data revolution has taught us in field after field after field, it's that human intuitions are not particularly good sometimes. And we see this a lot in language. There's mounting psycholinguistic research that demonstrates that human beings are awful about intuiting how other people use the law. We all assume that other people speak the same way that we speak, and other people use words the same way that we use words. And so when asked what is the ordinary meaning or the most common meaning of a word, oftentimes we actually overcredit obscure word senses. The most ordinary meaning we don't notice. It becomes furniture that fades into the background. Now, the Corpus Linguistics revolution wasn't the first time that people pointed this out, at least in the United States. And that's why in the 1980s, with the rise of prominent jurists like Justice Scalia on the US Supreme Court or Judge Bork on the DC Circuit, we started to see what was sometimes referred to as the dictionary revolution. And you'll see it's now very common for judges to cite dictionaries. The problem with using dictionaries, it's certainly better than nothing, but the problem with citing dictionaries for ordinary meaning is that we're asking dictionaries to do something that they can't do. If you think about the last time that you actually picked up a dictionary, sometime last decade, a hard copy of a dictionary, and you think about before you just Googled everything, and you think about the first few pages of the dictionary, those pages that don't have definitions, they just have a bunch of really, really small text. In English, we call that the front matter. It's okay if you didn't know that. Most people in the United States don't know that either. And those pages actually tell you how to use the dictionary. And literally no one has ever read that. It was written by some lexicographer and then everyone skips it. But it's really interesting. Most dictionaries will say that they ordered the definitions in one of 2 ways. They will either say, number 1, the order of the definitions in the dictionary is totally arbitrary and mean nothing. Or they will say, we've ordered our definitions in this dictionary in terms of historical attestation. So the oldest known definition is first. Well, the problem is that judges and lawyers often treat the first definition in the dictionary as a proxy for the most common. I mean, there are several United States Supreme Court cases where the justices will say the first definition in the dictionary means this, and therefore that has to be the ordinary meaning. And if you go and you look at the very dictionary they're citing, it will say, we've ordered them in terms of historical attestation. So in at least one case that we're going to talk about in a little bit, a man went to jail for 5 additional years because back in the 1400s, the word carry meant something that it doesn't really mean today. And that's a problem. Similar problem is etymology. Etymology is the study of word origins. And so it's very common for judges to when they're reasoning, especially in a language like English, which is such a bastardization of so many other languages. I mean, we've got loan words from French, loan words from German, loan words from Italy. And so it's very common in a judicial opinion for judges to say, well, this word comes from the old legal French, which means such and such. And then that came from the Latin, and in Latin it means such and such, and so therefore, this is the meaning of the word. The problem with this, and see if you follow me here, words do not always mean what they used to mean in Greek. Language evolves, it changes over time, often in ways that we can't perceive. So my favorite story about this, and it's possibly apocryphal, but after the Great London Fire in the 1600s, the most prominent church in England having burned down, St. Paul's Cathedral, there was a contest of architects to design the new St. Paul's Cathedral. And Sir Christopher Wren was told that his design had been selected because it was simultaneously the most awful and the most artificial. Now, awful and artificial today in English are definitely insults. But in the 1600s, they were the highest praise. Awful meant inspiring awe, and artificial meant designed with art. But language moved on for reasons that we're not entirely sure. And so basing a judicial opinion, especially when someone's life is at stake, or their liberty is at stake, or their company is at stake, seems really silly. I'll skip morphology. It's kind of related to etymology, but it's slightly different. The point is, a lot of these tools that judges and lawyers do use to talk about language are not very helpful, which fundamentally leaves us at a crossroads. We have kind of 3 choices as a legal profession. The first choice is that we can give up. We can abandon what scholars call the standard picture, this hope that our legal norms are somehow tied to the texts that legislatures or regulatory bodies have written. And quite frankly, I talk with a lot of judges. I travel the country, or at least I did before COVID. I traveled the country and I meet with judges around the country. And quite frankly, I don't see anyone who is advocating for this, to just give judges the power to enact what they think is the best policy. Number 2, we can keep using faulty tools. We can cover our eyes and cover our ears and pretend that we don't know that dictionaries and etymology and intuition doesn't get us to the promised land. And there are some scholars who make this point. And if I had more time, I'd tell you why they're wrong. I guess we could do this, but it seems intellectually dishonest, quite frankly. And number three, we can confront the problem. We can do the hard work of developing the theory and the methodology and the tools in order to help judges and lawyers make better arguments about the meaning of language that appears in the law. And that's what the Law and Corpus Linguistics project is really about. It's about embracing the big data revolution and developing tools that judges and lawyers need in order to tie our legal norms and our legal arguments to laws that have been passed by parliaments and by Congresses and by legislatures. Is it perfect? No, it's not. It's like any field. We're in the embryonic phases of this. And as I mentioned at the beginning, we like arguments, we like criticism because it makes us better. So I'll skip this. The point of this is that the U.S. Supreme Court is interested in it. These are various prominent judges across the United States who have written judicial opinions pleading with lawyers to start making corpus-based arguments and basing their opinions on the basis of corpus linguistics. Coming up on the time that Dr. Penn gave, and I really want to give time for questions. So I won't dive into. I was going to show you what the most prominent databases are, but I'd rather show than tell. So I'm gonna let me pull up another.
You can allow yourself some more minutes just to give the attendees a clear idea of how corpus linguistics works.
Yeah, that's what I want to do. I want to give an example and show you guys how to do it. So I'm just going to pull up a corpus, and then maybe we can talk through a problem itself. So we'll go to a practice problem, and then I'll walk you through how it works. So this is the case that I mentioned. This was a real United States Supreme Court case. Frank Muscarello was arrested while trying to purchase drugs. When his car was searched when he was arrested, officers found a handgun locked in the glove compartment box of his vehicle. When sentenced, the judge applied this particular statute, which was a 5-year sentencing enhancement provision passed in 1967 that applies to any person who, during and in relation to any drug trafficking crime for which the person may be prosecuted in a court of the United States, uses or carries a firearm. And so the question was whether or not Frank Muscarello was carrying a firearm at the time of this drug crime. And it went all the way up to this U.S. Supreme Court, and Justice Breyer, who I deeply respect, but I think he got wrong in this particular case. He said, well, the first definition in the dictionary of the word carry is to transport from one location to another, as in a wheelbarrow. And so if you can carry something in a wheelbarrow, you can carry something in a glove compartment box in a car. And so you go to jail for 5 more years. Frank Muscarello's argument was, well, that might be the definition of carry, but carry a firearm is an idiom. It's a unit in and of itself. And when we talk about carrying a firearm in English, most of the time we're talking about carrying it on your person. So this is a really good opportunity to show you corpus linguistics. So let me pull up a screen here. We'll go to, there's a suite of these databases that are publicly available that have been designed by BYU. And we're going to use this one called the Corpus of Historical American English. And I'll show you kind of how you use these tools. So let's say we were interested in knowing what the word carry was. If I type in the word carry, and then I specify that I am specifically interested in verbs. And then I click on this button over here, which is called collocates. Collocates are just words that like hanging out with each other. So peanut butter and jelly, they're words that just frequently appear together in a particular language. And let's say I'm interested in firearm, but not just firearm. Maybe I want to see carry a gun or carry a rifle, synonyms of the word firearm. I'm going to go ahead and put an equal sign in front of it, and that there's a built-in thesaurus here, and so it will search for the word firearm. Now you'll see, and all of its synonyms here that appear in proximity to the word carry. Now you'll see a bunch of numbers down here. You can expand this out to all the way up to 9. So we'll just do that for kicks and giggles. There's various data scientists disagree about how large of a spectrum you should do. But let's just, to show you the breadth of this, let's just do 9 on either side. So this is going to look for firearm or any synonym of firearm that is within 9 words on either side of the word carry. And then if you click down here on sections, you'll see a bunch of years. And this was a 1967 statute. And so in order to get, in order to capture the time period, I like to do 5 years before the statute was passed and 5 years after. So you get an 11-year span. So we'll go you can click 1962 and we'll go up to 1972. And we're limiting it to the time period in which the actual statute was passed. And if you then hit find collocates, it'll come up and you'll see this is not the full thing, but I'm just showing you what it will happen originally. It says, okay, we've got 53 examples of carry in proximity to gun, 38 examples of carry in proximity to weapons, and so on, all the way down to 1 example of carry in proximity to the word handguns, or a form of carry. I forgot to mention, that's the reason I put both of these in caps lock. By putting it in caps lock, you get carry, carrying, carried, all of the different verb forms of that word. So then if we click context, all of a sudden the database produces every single example of these words appearing in proximity to each other. Now, this is the part that lawyers and judges don't particularly like. Because in order to do an effective corpus analysis, it takes time. Sometimes it can take a full day or maybe a couple of days. We've got about 300 examples of this appearing in the database. And when I do a corpus analysis for a brief or for a scholarly article, my rule of thumb is if there are 500 examples produced by the database or fewer, I code everything. I look at every single one of these examples, which is called a concordance line. And I code them by hand. And I say, okay, I'm carrying, we can look at this one. This is from a fiction book, a short story. He brought the Jeep in slightly, leave your vehicle. The speaker chattered. If you are armed, leave your weapon behind. It is not my weapon to carry a gun. Keenan snapped. So again, looking at context clues here, the fact that he's getting out of his car and he's being told to leave his weapon behind, and he's saying it's not my habit to carry a gun. This is an example where carrying a firearm is clearly on his person and would exclude his vehicle. And so what I would typically do is I would create a spreadsheet where I would copy and paste this and some basic information. And I would say, okay, this is an example of carrying it on this firearm. And I would do that for every single one of the what we call concordance lines, or basically the hits that the database produces. And it takes, no doubt, it takes time, but judges really like it. Whenever I submit a brief that does this, I always provide a hard copy of all of my data. And judges have talked about how one of the reasons they're excited about corpus linguistics is that it makes it more transparent. Now, you may disagree with, there's always wiggle room here. There are some times that, you could code one of these and two different people would disagree about the right way to code or which bucket to put this particular, which bucket or sense this particular sentence is exhibiting. Or one person might just say, gosh, it's ambiguous. And the other person might say, no, I think it's this. But the big data makes the decision transparent. A judge can go through and it can look at my spreadsheet and say, you know what? I really like his data. I don't like his coding, and I'm going to redo it. Or they could look at the spreadsheet and the data and say, well, this is good data, but he's clearly, trying to pull one over on the court, and I just don't agree with his coding, and so I'm just not going to trust it. His argument is irrelevant, and I suddenly don't trust him. Conversely, they can look at my data and say, wow, I'm right on board with what James is doing, and I really trust his conclusions, and therefore I'm going to cite them. And there's always this incentive in an adversarial system like the United States to carefully choose your arguments and to maybe carefully obscure evidence that isn't very helpful for you. Corpus linguistics, again, exposes it. It exposes it for lawyers and exposes it for judges. Now, I can tell you, having done this search many, many times and coded all of this, the vast majority of times that in the United States, we talk about carrying a firearm or carrying a gun, it's about 85% of the time we talk about it carrying it on your person, in a holster on your side or in a backpack. There are almost no examples of carrying a firearm in a vehicle. Now, there are some theoretical questions that you have to ask, beyond that we don't have time to cover in this. But I will just share one story that's really interesting. The very first judicial training I ever did, there was a justice on the Idaho Supreme Court that attended that training. He's a good friend. His name is Justice Bevan, and is quickly becoming one of the nation's leading advocates on the bench for corpus linguistics. But when we first presented this particular practice problem, he looked at me and he said, gosh, I've got I had a case that was almost identical to this one, and I am positive that Justice Breyer got it right. And then we spent 30 minutes together on this database. And after about 30 minutes, he looked at me and he said, oh my gosh, I was wrong. And he was the one who pointed out something that I had never seen before. He said, every time that it's talking about a vehicle in the context of carrying a firearms, it's the vehicle who is doing the carrying. There would be sentences that say things like, the Army truck carried the rifles to the front line. But this particular law doesn't regulate the behavior of Army trucks. It doesn't regulate the behavior of vehicles. It regulates the behavior of individual people. And there's a 5-year sentencing enhancement when people carry a firearm, not a vehicle carrying the firearm. Let me show you just one other cool example, and then we'll open it up to questions. This is another real case. Names have been changed. Dastardly stole an airplane and flew it from New York to Colorado. When he landed, he was arrested for violating a 1919 federal statute that makes transporting a stolen vehicle across state lines illegal. As part of his defense, he claims that the ordinary meaning of the word vehicle does not include an airplane. What sort of corpus would you, well, we'll ignore that. So just again, going back to our database, let's say we were just interested in the years. For simplicity's sake, we can do decades. We'll do all of the 1910s and all of the 1920s. So we'll have a 20-year span. And let's say we're interested in whether or not the word airplane or any of its synonyms have ever been referred to as a vehicle around the time the statute was passed. Let's see if the technology will work with us. Oh. Okay. There we go. Let's try this again. So we'll do vehicle, airplane, expand it out just for kicks and giggles to 9 words on either side. Oh. And forgot to specify the years. And you'll see that even though there are millions of words, I mean, there are 40 million words included in this database that were produced between 1910 and 1929. There is only one example in the entire database of the word airplane, or here aeroplane, being used as a vehicle. Now, when I did this example at the Ohio Supreme Court, one of the justices said, very astute, said, well, you know, this is really interesting, but the next thing I would want to know is whether or not airplanes are being referred to as something other than vehicle. If people are never referring to them as vehicles, and they're using some other word, then that's a really good evidence that the statute doesn't apply to airplanes. And one of the other justices spoke up and said, well, you know, I grew up in Southern Ohio where the automotive industry was really big, and we didn't refer to cars as vehicles. We usually refer to them as machines. So do airplanes ever get referred to as machines? And so I had never done this before. And so I was like, well, why don't we find out? Let's see. And you type in machine, same time period. We'll try it one more time. Otherwise, I'll just tell you what it does. And you'll see a whole lot more examples of airplanes during this time period being referred to as machines. We could do other tests. We could look at whether vehicles fly. The answer is no. During this time period, nobody is talking about vehicles flying. Conversely, we could talk about machines flying. Lots of examples of machines flying. And so again, this is an example of, if we're really serious about having our language, having our laws and our legal decisions be reflective of how language is actually used, this is an example of when our intuitions might take us in an opposite direction, specifically because of linguistic drift. If you were to do the same search today, we frequently refer to airplanes as vehicles because language has moved on, language has evolved, it's changed. But if we care about enacting the will of the legislature that wrote this law, well then dastardly should probably get off the hook, at least under this particular statute. Now, just to sort of finish up, I know that a lot of your program focuses on artificial intelligence, and I think, and I suspect that is where this field is moving. I mentioned the fact that, corpus linguistics requires an awful lot of manpower, an awful lot of coding. And the reason for that is that the technology has not caught up to it yet. At BYU, we met with some scholars a couple of years ago that were working on the problem of sense disambiguation, being able to train artificial intelligence to go through a database like this and say, in this context, this word is being used in this sense, and then to produce all of the statistics and the data on its own. And they're making some really promising strides, but we're not there yet. There's probably crossover with machine learning. But as far as being able to have a computer program be able to look at a sentence and say, this word vehicle is being used in this sense, and this word vehicle is being used in that sense, we're not quite there yet. Am I optimistic that we'll be there in a decade? Maybe 15 years? Yes, I do. I think that's where this is trending, and there is a great deal of there's a great deal of work to be done for data scientists and machine learning experts to be able to get the tech in that direction. But in the meantime, I can tell you that at least in the United States, judges are very, very interested in this application of big data. I will share briefly, I did a little bit of searching. There are Italian databases. So this is one known as PISA, which is a modern Italian corpus, pulled with text pulled from the web. So it's probably not a historical text, but I'm sure that there is probably a historical Italian corpus out there. I just couldn't find it in my Googling. And then there's one called that is under development called Heilpern, which is a really interesting database that is being developed by some Italian scholars of spoken Italian, where with recordings of actual conversations, because people talk and write in different ways. So there are not yet, I have not yet seen any foreign jurisdictions other than the United States, outside of the United States, applying corpus linguistics. But as happened with the dictionary revolution in the 80s, that eventually spread to other jurisdictions, I expect that as the as other corpora are being developed for other languages, I would not be surprised if we saw these tools and technologies eventually infiltrate other jurisdictions as well. So I'll leave it at that, and we can turn the time over to questions.
Thank you so much. It was very good presentation, and thanks also for pointing us out to the Italian databases in the field. Thank you so much.
No worries.
I have one initial question just to kick off.
Okay.
So I think that I wonder how you feel with conflating the conceptual framework with the fact of the collocation. So you're looking for collocation words, and you infer the meaning of a word depending on the collocation, not on the concept themselves. So I wonder how you feel with that.
So if I understand your question correctly, you're asking about how I came to certain conclusions based on collocation as opposed to just looking at the word in isolation.
Right, because word is not just a word; it's a concept, right? You spell out through word. Yeah.
Exactly. So there's there's a famous there's another famous U.S. Supreme Court case called Smith v. United States, and it was another Supreme Court case that arose out of the exact same statute, the carry a firearm statute, but it was analyzing a different phrase, which was use a firearm. And in this particular fact pattern, in this particular case, Mr. Smith had traded a particular firearm. I want to say it was an AK-47, but it might have been some other firearm. He had traded his gun for drugs. And the question is whether or not he had used his firearm in that transaction. And it went up to the Supreme Court, and Justice O'Connor said, well, again, she turned to dictionaries and she said, well, let's look up the word use. And based on the definition of the word use, I mean, yeah, this might be a weird use of a firearm, but it definitely is a use. I mean, he traded it. I mean, that was a use of a firearm. And in a dissenting opinion, Justice Scalia said, well, that might be the definition of the word use, but that's not the meaning of the full phrase, use a firearm. When we use the whole phrase, use a firearm, we're talking about firing it. You know, if I talk about using a cane, I'm not talking about it hanging it on my wall as an ornamentation. I'm using a cane to help me walk. That's what the ordinary meaning of use a cane is. And so what this highlights is that there's some language theory here. We don't in any language. I lived for a couple of years in South America. I was a missionary for my church in Uruguay, and I did not speak Spanish before I became a missionary, and so I had a very intense language study. And any of you all are fluent in English, so you probably remember this when you were first learning English. There's a lot of learning phrases as opposed to learning words, because that's how the human brain works. We actually think in clusters of words as opposed to individual words. And so, this gets into the legal theory questions that I was highlighting. One of the legal theory questions that judges have to ask at the very beginning is what is the phrase we're interested in expecting? Are we interested in just the word carry, or are we interested in the full phrase carry a firearm? And those are questions, how to identify those questions. I mean, as a lawyer, it's easy. As a lawyer, you run all of the searches, and then you pick the ones that are the most advantageous to your client. And those are the ones you give to the judge. Judges have a harder job. They need to lead out on this and to tell us how to figure out what the right phrase is. And there's some really good, and scholars certainly have a role in this. And there is some really good scholarship coming out of various law schools in the United States that talk about how to figure out what the right unit, what you might call a semantic unit, what the right cluster of words is to figure out, and how do you figure that out? So, good question.
Thank you. I think that there's a Lisa Spiller who joined us. She teaches law and data here at the University of Padua. I think she's
Yes,
Mr. Jennings was asking a question. Yeah, please go ahead, Elisa.
Thank you. Thank you for the very stimulating presentation. So my question is a question coming from a EU law scholar. So in the EU, we have a piece of legislation that is translated in 27 languages. Do you think that the approach suggested by the Corpus Linguistics could be helpful in this field for comparing the different meanings that the same expression may have in different legal contexts?
Yes, absolutely. And I would recommend looking up some work by a scholar named Larry Solin. That's Solan. He is a scholar. He is both a linguist and a law professor at the University of Brooklyn Law School. And he serves on BYU's Board of Advisors for the Law Corpus Linguistics project, and is a good friend. He's done some work, some of the initial work on multilingual applications of these tools. It certainly is a different. It's a different animal. I have one of my best friends is Canadian, and in Canada they have it's a bilingual jurisdiction. Every piece of legislation, every court decision is authored in both English and French. And when he told me this, it blew my mind. The concept of a legislation being in both French and English, and both of them are the official piece of legislation. Being a bilingual person myself, there are words and concepts that just don't translate. And so it's an area that I've always wanted to dive into, and my research hasn't gotten me there yet. But I certainly think, especially I'm not sure if the EU is the same, but in Canada, the fact that both the English and the French version of the law are the official law. I can see what it would require is, I think it would require first looking at what do, say, the European Court of Human Rights or the international courts that have jurisdiction over all 27 countries, what are their legal theories and the theoretical framework that they already use to handle this problem of multiple languages, and then trying to adapt those theoretical frameworks to the corpora, to the databases. I mean, that's largely what we have done in the United States. Is we're not inventing new. I think we're on the cusp of inventing new rules of thumb that judges should be using. But for a lot of it is we have just taken what judges have said at face value. Judges have said, for example, that when interpreting the law, we should care about its ordinary meaning. And then they explain why they care about the ordinary meaning. And so what the Law Corpus Linguistics project has done is we have taken them at face value. And we have said, judges, you claim right now that you care about this ordinary meaning concept. And here is a way to quantify it. And so having never really studied never having gotten to the point where in my scholarship I've been able to look at this particular issue, that's where I would start. I would start by looking at what the judges have already said they care about, and then looking at a way to quantify it. And if this was an area of scholarship that you were interested in pursuing, Professor, or any of the professors, I have a number of very good friends who are European linguists that I could pair you with. And I think that this would be, quite frankly, I think that this would be a fascinating project that needs to be done. I could pair you with some linguists and you guys could go off to the races, and I could almost guarantee you a place at next year's Law and Corpus Linguistics project if you wanted to present. Because I just think that this is a fascinating subject that needs to be explored more.
Thank you so much, James. Thanks for the generous offer. I'm sure Elisa will consider that attentively. So I know Samir has a question. While Samir asks his question, let me remind students that those who are following us through YouTube can email us at aisociety.unipd@gmail.com. Samir, go ahead.
Thanks for the great talks. Jim, I would ask a question from a different angle. Let's say I'm a physicist, and I see.
I'm just gonna let you know I never took physics.
Don't worry. It's just about. I see that there is a lot of potential in. I mean, you mentioned this in machine learning and artificial intelligence research. In corpus linguistics, because you show basically that up to now the machine learning is simply using to retrieve from the big data all words that you specify with some condition and some collocation. But of course, I was intrigued by the fact that you use the word computation when you want to express your analysis of the text, right? So you do a lot of computation by hand.
Yeah.
And of course, much of this computation somehow, if it's systematic, can be somehow implemented in algorithms. So I think it's really, there is a lot of room to go and perform and automate automatize this kind of processing. So my question is, how is in your world? I mean, do you collaborate with data scientists that are grouped with the people from different disciplines working together? How you develop in the corpus linguistic research this kind of branch that is more technical?
So this is a good question. I mean, law and corpus linguistics is by definition a multidisciplinary field, and it's very new. It's a very new field, and so most of what we have done, so BYU is kind of the flagship right now for corpus linguistics research. They host the annual Law and Corpus Linguistics conference every year, and are really sort of at the forefront of the leadership. And one of the things that we're very committed to is forming relationships between disciplines. Now, for obvious reasons, a lot of those early cross-disciplinary relationships have been between the field of law and the field of linguistics. But we certainly have discussed, the need to branch out, the need to develop and foster more relationships with data scientists. Within the machine learning world, well, even before that, within the linguistics world, about 20 years back, there was a kind of a schism in the scholarly disciplines of corpus linguistics and natural language processing. And they kind of went in opposite directions. And we're very cognizant of that and trying to prevent similar schisms from happening in this very novice movement that we're trying to create. And so a lot of what we're trying to do is just to create relationships. At last year's conference, we made a requirement, for example, that every paper that was presented had to have at least one lawyer and at least one linguist. on the paper to force the interdisciplinary nature of the field. And so one of the things that I would encourage is maybe just starting out by attending some of the conferences and meeting the people and asking these questions. Because of COVID, this year's conference, which will be held on February 6th, is going to all be online. It's a virtual conference, which is not as great, but I will certainly send details to Dr. Penn and ask him to distribute it. We are constantly looking for new people who are interested in this field that can bring new observations and help us think of things that we haven't thought of before.
Thank you very much.
I don't know whether any other question has arrived. Meanwhile, I can just emphasize one thing, James, I think, because of course these projects started in the United States, where there's certain legal culture which is based on courts. But if you look at the possibilities of the program or the project itself, it's awful in a very ancient way, in the sense that, for instance, you can provide legislators with a sense of what kind of drafting would be the best drafting, while they are nailing down the wording for the law, and everybody would be pleased about that, right? Yeah. Or the Court of Justice or the European Court of Human Rights, they issues judgments in just 2 languages for 47 states, so just French and English, and they often peruse the legislation of countries, wondering whether the quality of legislation is good enough, etc. And they have huge numbers of applications, and this makes the European Court of Human Rights a perfect marketplace for your ideas, I think. Yeah. It's huge jurisdiction, just 2 languages, and very lengthy opinion, and they deal with human rights, only with human rights. So I think that what you are talking about certainly developed in light of American doctrines and American jurisprudence, but with some adjustments, you can certainly find a place somewhere else, and many places around the world.
Yeah, and this kind of brings up something that I've thought a lot about. I've mentioned that there's a lot of scholarship that is critical of corpus linguistics because it's new and it's unusual, and judges and lawyers oftentimes don't like learning new things, and all of the reasons that people who are familiar with the history of big data have seen in field after field after field after field. But one of the things that I keep coming back to is that the future is unknown. Like what the actual ultimate implications of this will be, it's hard to imagine. So the analogy that I like to use is a few years ago I read an article by the CEO of GM, who committed that they were going to produce a self-driving car that produced 0 collisions, 0 emissions, and 0 congestion. Now, let's leave on the table the question about whether or not that's possible, but let's just assume it is. Let's just assume that 10 years, 15 years in the future, we're going to have self-driving cars that will have no pollution, no traffic, and no accidents. When most of us think about self-driving cars, we think about something that looks an awful lot like a sedan, like a four-door car, and we're all facing forward and we're wearing seatbelts, and everything is exactly the same except we're not driving. But if we really had the technology that was able to guarantee that there would be no accidents, no pollution, and no traffic, why on earth would cars continue to look the way that cars look today? Why would all of the seats be facing forward rather than facing each other? Why would there just be seats? Why wouldn't we start seeing fold-out beds? Why would cars be limited to the size of a traffic lane when, the technology exists to maybe make a larger vehicle? And the possibilities are almost limitless. We can't imagine. I mean, this is the problem with all science fiction, is we always imagine cool technology and then we try to insert it into our current culture because we're not necessarily good at predicting how the technology is going to change our culture. And I view the same thing with corpus linguistics. We're very, the first law review article ever written to use corpus linguistics was written less than a decade ago. And we've really only seen judges begin to embrace corpus linguistics within the last 3 years. And it's increasing at an accelerated rate. And once it becomes commonplace, I don't know what it's going to look like. I mean, the applications that you proposed about being advisory to parliaments, I think has huge applications and huge implications. The possibility of judges in multilingual jurisdictions consulting corpus linguistics in order to help them be careful about their word usages also has huge implications. And then if those are widely adopted, how does that further change our legal culture? It builds, technology builds and applications build on each other. So I think that's a very astute, and I will say that right now on the legal end, the law and corpus linguistics community is very heavily skewed American. Our linguists are more diverse. We've got one of our most prominent linguists that writes a lot in this field is from Croatia. But happens to teach in the United States. I think that's the reason, is that there's a lot of European linguists who have migrated to American universities, more so than European legal scholars have migrated to American law schools. So that being said, I think it would be really exciting to find ways that our institutions could collaborate. I'd be, maybe we could collaborate together, in a post-COVID world of putting together, the first European law and corpus linguistics conference, maybe there in Italy, and work together to start fostering the same sort of community, or finding scholars, both legal and linguistic scholars. And Samer, your comments about data scientists and physicists, and trying to get some European scholars interested in it, because the more minds that we have working on these problems and thinking about how big data can help improve the legal world, I think the better.
So thank you so much, James. I think it's time to wrap up at this stage. Let me just thank you on behalf of all the group. I'm sure everybody liked your presentation. Let me just say to the attendees that we look forward to having the Vice President of the Italian Authority for Privacy on December 4th. It's going to be in Italian, unfortunately. But so just look out for more information on our website. And stick with us for a moment, James. So once we say goodbye to everybody, we'll say properly goodbye to you. Okay.
Also,
Thank you so
let
much.
me thank also the Matteo Menguzzato, Roberto Temporin for the support.
Thank you, sure.
For the webinar. Thank you.
Thanks, Samir.
And Dr. Pin, if I was serious about what I said at the beginning, if you could please maybe email your students my email address, and if any of them are interested in reaching out, I would be more than happy to field their emails and to develop relationships with them.
Sure, I'll make sure they receive it. Thank you so much.
Thank you. Thank you.
Bye, everyone.